22, and we welcome everybody here. I think we have a representative from all the critical groups. And we had a challenge on the search and seizure provisions, whereas DPP can give us some comments on, if you recall, I think Mr. Golding and AG had the question of search and seizure, similar to those identified in the context of cybercrime. There was some concern on that, if I recall correctly. We started page 21 with the whole process of surveillance, where they did this define surveillance officers, treatment of non-national and so forth. Went over into page 22, and I think there were some issues raised on the search and seizure issue. It was the amendments come then. No objection or concern.
Chairman, it may be helpful in looking at the power of search and seizure to determine if it may make sense to have a default position of requiring a search warrant, and then to look at circumstances which may warrant search without a warrant for practical purpose. But I think as a general rule, search should be done pursuant to a warrant. But we recognize the dynamics of circumstances for investigative and other purposes where it may be practical and necessary for the power to be exercised in the absence of.
I like to have to be guided how we structure that into the guidelines we give out now. Ms. Grant, you're comfortable with that in terms of how? So if I understand correctly, the default position is we should have a search warrant, but we need to define. AD, let me understand from a layman's point of view. The default position, we should have a warrant, but there are conditions under which we should define the condition under which would do so without the search warrant. Nigel? Yep. Would the Jamaica JSC submission satisfy your AG? Would the JSC submission satisfy your? Yeah. Great.
Chairman, perhaps the default position could be for an officer of the JCF of a particular rank to grant the warrant in the circumstances, which I imagine would be emergency circumstances which would not allow you to go before a parish court judge or a justice of the peace. Outside of that, I can't think of any circumstances where it would be desirable for you not to obtain a warrant from a justice of the peace or a judge of the parish court.
Chairman, the JCF's recommendation is that authorization to search should reside with a JCF officer of the rank of inspector or higher. That's what they have proposed here. I mean, this would...
Under what condition? In a condition?
Yeah, he would authorize the constable to do the search.
In an emergency situation?
Well, it doesn't say that. So, I mean, maybe it ought to be couched in that way, that if the inspector is satisfied that if the search doesn't proceed forthwith, there's a high likelihood of the disappearance of, of relevant evidence, then he can or she can authorize the search.
I would go with that. I don't know.
Perhaps, Chairman, we could spend a little time just looking at it from practical perspective. So the police may have intelligence that they are acting on, and pursuant to that intelligence, they are embarking on further investigation in a very targeted and organized way. Where that is so, naturally you would have information ahead of time, you would be prepared so you can get a warrant. But investigations do not always take place in that context. And an inspector or a rank above may not always be among the team of police officers on the ground in community investigating or responding to allegations of gang activities. And so we have to ensure that in legislating we can appreciate what is required in both scenarios, and at all times guard against arbitrariness.
Right. What I see happening, if I ask, and I seek your opinion there, as they're both legal. If the team is out with a warrant for house at number 10, then, but when they get there, based on immediate information, because of somebody that is credible, or their own analysts of intelligence, when they get there, they realize they might have, in fact, they should have taken the opportunity to look at both houses. Then at that point, you may have to make a decision. That's the kind of state you could see varying, but they should have a warrant in going there in the first place. But you could have a stage where it is now desirable to look at both residents in that particular location. I don't know if that's
not one possibility. Is there also a situation where they could be doing an operation or a patrol, and while they're on the ground, they hear shot fire, and then they get information that the man threw the gun under the cellar in that yard, or something of that nature, and they want to be able to, I mean, the inspector may not be present, but he may just be a phone call away to give the authorization. I don't know, I'm saying that,
an experienced officer of some line, I don't know whether you go for a sergeant or inspector or the time would be on patrol. Usually the patrol cars carry a corporal with them. Saying it should have, you don't want to delay. If it's a genuine emergency, you may not want to delay. I'd be advised. What's the view?
But it will be routinely abused if there aren't appropriate safeguards.
I agree that the default position must be you get a warrant to proceed based on intelligence you can identify. And I'm seeing from MOCA. Based on intelligence, you're going to search A, B, C, D. But in getting there, I would want to see it become a habit practice, but there may be good reason to search another venue or in the situation you have described. They're on patrol and they get hot information. Something is in that place that needs to be checked now. But that, in those circumstances, you'd almost have to say whichever officer is in charge of the operation or on patrol, the senior person would have to give it, should be allowed. I don't know.
Given the raft of circumstances that are being discussed now, I think the most practical person to grant the warrant would be an officer of the JCF, since in those contemporaneous circumstances it might be the easiest official to put the circumstances before to get the warrant. I don't know if in a contemporaneous circumstance where you're on an operation, you hear gunshots and you respond to it, those circumstances would necessitate pausing what you're doing to obtain a warrant. I think if you're in pursuit of an active situation like that, you might not need a warrant. Of course, the elapsation of time between when you get the information and what you're doing would have an impact.
It may be, Mark, we have to proceed with the non-default version to, in those situations, allow the officer to proceed. But I think it's the kind of thing we'll have to monitor and have some guidelines somewhere that it's not abuse. So somebody turns up, because the circumstances are both ways. You turn up in an area that is managed, literally controlled by the gangs. You may find you have to move quickly, but it has potential to be abused. Therefore, we'll have to look at how accept the default position, and then agree we have to give permission from the senior officer on the operation. I'd also ask this as an issue here. Since Nigel, Mocha will be autonomous very soon. So practically will be legally a separate body with police powers, and may in fact be engaged in some operation. Would we want to give a Mocha agent on an operation the right to do so? They may in fact be more sensitive. The person that might be investigating may be a police officer. What is AG? All right, Mark, Donna, you're the lawyers. I'm just saying,
under the Mocha Act, they're given the powers of a constable and a Mocha agent.
Yeah.
Yeah. But that would not include the power to...
If I may, Chairman, in fact, you'll recall that due to two decisions that came out of the court, we had actually done some amendments to at the time, the Mocha bill, to go further, to not just give them police powers, but to give specific powers that were listed in a schedule that would allow for search. So if Mocha is going to operate, they would be able to operate under their law. That gives them very specific powers, taking into account the guidance we got from the courts to say that when it related to Indicom, just saying police powers did not give them the sort of powers that we all thought it would give them. So Mocha has been given very specific powers that they would be able to exercise under their law.
They don't need a warrant to do a search?
I was just looking for the act. I can't find it on Parliament's website, but it needs a warrant. I'm pretty sure they would need a warrant.
Well, that's we're adopting a default, but I'm saying if in this case in the anti-gang act, because remember, Mocha plays a critical role in investigating the gang, even from in fact at this point. Now, bear in mind that they too might be dealing with gang once you get to that level. Yeah, they will gang that cross all the professional line. They may want to do a search. They may need to do a search without going for a warrant.
Is this intended as a gang-related provision or a general power?
I'm referring to.
But I mean, the police may be in a community, get information, and it may not be a hot pursuit situation, but they just have information that their weapons stashed.
Yeah, we have to have the default, but we have to give the police some authority.
To me, that should be a general policing power rather than something limited to the investigation of gang offenses.
I think there has been some hesitance to give the police widespread powers to search, despite the circumstances we have. And I'm inclined to agree with you, but I think the current thinking is always to have a warrant before.
So, Chairman, under the Zozo Act, the police do have the power to search, and it's not just premises, no, it's premises, property, vehicle. Let me find it. without a warrant. It's any place, vehicle, or person, and it's without a warrant. But they have to have reasonable suspicion that an offense is in the course of being committed, or has been committed, or is about to be committed. So it does exist, and I'm trying to find, I know
Right.
part 2 of I'm going to look at part 2A of the Constabulary Force.
Essentially, what we are trying to do is to bring this on the anti-gang as well. But we are not making it as I've been thought wise to give the police total power to search without a warrant if they have a high level of suspicion. You're saying a high level of suspicion in a zone, which means the community has been defined as having challenges. And in this case, it's an area where a gang is operating. Then they have, it would almost be a replica of the ZOSA Act.
That's not clear.
Constabulary Force Act also gives you the right to do that. That was what. There was actually a ruling by Justice David Batts, which I think has been misinterpreted with this, where the policeman stopped the vehicle and searched, because what was missing was the element of reasonable suspicion. And so I think that once you can establish the reasonableness of the suspicion, you could proceed. I'm trying to wrestle with it if there's any other way.
So the problem stems from how the power is granted generally under the Constabulary Force Act. So you have at Section 19 the power to stop and search vehicles without a warrant. And then you have under Part 2A, which is the old suppression of crimes provision, the power of a search where there is a cordon, but there is no general power. When we were doing the law reform, ZOZO law, we created a provision, which is what the Solicitor General just referenced. And I think that is the kind of provision that we need generally for the police. In respect of the, is it nation matter? It is a randomness, it's a random stop and search that the law found that it could be arbitrary because you have no reasonable cause to suspect if people are just going along and you're going to stop them randomly without having reasonable cause to suspect that they have committed an offense. That the inclusion of reasonable cause is what takes the exercise of power out of the realm of arbitrariness.
You're saying that would need to include such a clause
Right.
in
So
the Anti-Gang Act.
what we had done, I think, Chairman, what we need is a general investigative powers to the police that they can use across a wide subject area. Now, it is true that this law, the suppression of criminal organization, does not have any provision dealing with the police powers, and the police powers under the Constabulary Force Act are specific. In specific and limited circumstances. So we can accept the recommendation, but I believe that it may not be, the real solution lies in creating a proper power in the Constabulary Force Act, as we have done in circumstances where a zone has been declared, so that they know they have the general power.
That means a police can just come to my house and just say,
Shouldn't.
I want to search your house. I suspect that you have Mr. Chang's secret papers.
What you're saying, we would need to have a recommendation in the Anti-Gang Act until you're saying we don't need that.
I don't think we should create a specific police powers for type of offense, because the powers are needed for serious offenses generally. So, including these under this anti-gang legislation, but equally so for firearms offenses, serious sexual offenses, and serious offenses against a person, such as murder. So, if the police find that the existing powers of search are too procedurally restrictive, then the question is what loosening of those restrictions is appropriate. What they have asked for here is that as opposed to a warrant being required, a senior officer can give the authorization. I'd suggested if that, we could look at that, if the senior officer is satisfied that if that authorization is not given, vital or cogent whatever evidence which may disappear and not be available to support a prosecution, and therefore that would be a ground upon which the search could be made. I think it should be a person of a senior rank. They may not be on the patrol, but they should be able to contact them.
I think we need to put something in this legislation. Because while I understand what you're saying about the need for maybe broad loosening, at the current situation, and I guess while laws shouldn't be done for current situation, the gangs really are the operative team for a lot of the challenge we are talking about. The gangs have the guns, they're involved in the extortion, they organize a lot of the things around them, and they're members who get involved in much of the other thing, abuse that we're looking to overcome. And when we do the Police Act, we maybe have to look at it, and is it desirable to give them that wide power? But certainly in the situation, I think, at this point, when the anti-gang legislation should give them some power.
If you do it that way, though, Minister, and when the matter goes to trial, the prosecutors feel there is not sufficient grounds to charge them for a gang-related offense. There's some elements that can't be proved, but there is a firearm or there are drugs. Does that mean that that evidence is not admissible because it was unlawfully obtained, because it was only lawfully obtained in relation to gang offenses? You see, you get into some potential issues once you start to parcel out powers and attach particular powers to particular offenses and not others.
I do share the view that the better approach is to provide for your suite of powers that are general investigative tools instead of particularizing. You can create your particular offenses, but insofar as investigating offenders, the better approach would be to create the menu of powers.
I'm seeking greater powers to the police, but there's the resistance to give the police too much power when they do this kind of activity.
It's not so much greater power, they have the power, but it's to reconcile what we have in the various pieces of legislation scattered all over the place.
The truth is that I think it's generally recognized that the conditions in the areas which are now under ZOSO, those conditions exist in many other communities. Currently,
they exist in everywhere. I'm agreeing with that, but they exist in everywhere. There are maybe 75 communities that are potentially, qualify for that kind of activities where the gangs operate, the active gangs. So because that's why you create a zone here. You have a gang that dominates or two gangs that are warring in the area. So, but, all right, what is the advice you need? The general.
Mr. Chairman, this proposal from the JSF actually, it seemed to be coming, are they requesting similar provisions like what's under the Dangerous Drugs Act, Section 21(4), that if any member of the constabulary force of or above the rank of sergeant is satisfied that there is reasonable cause to believe that an offense against the act is being committed in any premises, he may give directions in writing to the constable to enter the premises, search the premises, and seize and detain.
The recommendation here is to have a clause in here dealing with increased specific search and seize in areas where we identify gang. The suggestion is that we should do it on a broader scale, given the nature of the crime now, which means we'll be recommending that we look at an amendment to the JSF.
That provision that was just read, Chair, applies under the Dangerous Drugs Act, right? But the question is it not a power that is needed for other offenses In other words, creating these kind of silos of where powers exist to investigate this.
The recommendation, we should look at a generality, but where do we put that? Under the JCF Act?
Yes, I think so.
So we'll do an
the question is what
early
are the
amendment to the Act.
Yes, and a consequential, the bill amends.
Okay,
can
a consequential
that.
amendment
yes, in the
at this point.
same legislation that would do
Okay.
it.
All right.
Mr.
So
Chairman, I understand it's actually being proposed under the Constabulary Force Act, the amendments to the Constabulary Force Act.
Before we get to the full new JSF Act, what we're doing is do it now under this the schedule as the current situation.
Just for clarification then,
Okay.
this, under the Constabulary Force Act, currently, the AG had summarized the power of search that it allows. And that is if there's reasonable cause, that the reasonable suspicion that and then in the
a crime to be committed, have been committed, or about to be committed, or something along those lines.
That you can do the search.
Reasonable suspicion or doubt that something is happening in that particular location,
not that evidence is
property or otherwise, that there is something is there, so the crime or crime to be committed, or
I mean, supposing it is that there is a laptop with some vital evidence on it, and you believe it is stored under the floorboards in the bedroom of that house. Yeah. In that instance, do you have to go away and get a warrant? Or
I treat the same way we treat a firearm. With the modern criminal activity, we'd have to treat the laptops.
An illegal firearm is itself, possession of that is an offense. So it would fall within that formulation. But that's why I use a laptop as an example, because possession of a laptop is not typically.
No, the possession is not, but the content on the laptop may indicate what the crime is, and you need it in the evidence. So the recommendation is to look at making a consequential amendment to the JCF Act. Or just for my education, the JCF Act is the one that we had to. That was the cause of many problems, and then we amended all the clauses to bring it into the state to say no, we're not going back there. The suppression of crime happened on the police. That was where it came from.
Certain powers that were considered necessary to retain were put into the Constabulary Force Act when the Suppression of Crimes Act was repealed. So it was repealed, yes, but there were some things in it that were retained. And with the passage of time and the problems that we now have, what we're saying is that this seems to be something which exists in law already in relation to drugs, but it has a wider need for it.
General, all right, yeah. I'm with you. And yeah. I'm just want to clear that I'm satisfied that the recommendation here, then instead of putting another clause confined to a specific law, we look for a consequential amendment under the Constabulary Force Act. That's the study on the
Chairman.
Yeah.
My apology for being late. I had to rearrange because I had planned for 10.
I apologize, but we have not problem with the space, and the new parliament will catch ahead of us. We'll have to.
Am I to understand that this is a general power of search which does not deal with specifics? That is, that the search is for A, B, or C. Oh my goodness me, look at that. Has made that noise for all day. Or is it that it's a search at large?
No, the view is that the current position, the default position, I think is the term they use, is that you should have a warrant. But you are looking at where there's reasonable cause
Yes.
to pursue search, and that a request was being made to insert such a clause in this law.
No,
The suggestion is that we should.
I understand that.
No, the suggestion is that we make a consequential amendment to the existing right to search under the JSCF Act, which would provide for where there is reasonable cause that an officer of an inspector level can give permission to search.
Yeah, but reasonable cause to search for what?
Yeah.
Just to go and search?
Yeah, I think that if you're going to depart from the common law, which requires a warrant, then it has to be, the situation has to be one in which the senior officer that's going to authorize this is satisfied that it's necessary to proceed with right away, because otherwise, it's searching, so it's about the preservation of evidence, isn't it?
Yeah,
Yes.
it is, but my point is, are you net fishing or spear fishing? Are you going to search? Do you have reasonable cause to believe that a laptop is there
With
or
evidence.
with
relevant
evidence or
The member came in, there was, as they do, before I come in, this scenarios described on member night is that you're on an operation, and let's leave out the firearm, which is itself for now. You're in the operating area, there's a gang that is involved in heavy scamming in Montego Bay. They are the big gang in this particular district. The police comes in, it's a populated area.
I understand.
They move the laptop next door.
I understand.
They see them move the laptop next door, and the police is informed. He needs the right to go and pick up that laptop. That's what they're seeking to do here. That's why I understand in layman terms.
So
Yeah, that's one example. You could make up many different things. Yeah.
So they go to search for, when the senior officer, let us say it's a senior officer, gives the permission to search, is he giving permission to search or to search for A, B, and C? Or is it that you go into a person's home and you just dig up the people's place and say you have reasonable cause to believe that evidence is there? What evidence? And same goes for whatever you're searching, vehicle or otherwise. I just want to know.
If I may.
Chairman, when we look on the offenses that are under the Act, in the first place, it must relate to having reasonable cause to believe that a member of a criminal organization may be found in a particular place or premises. Or it could be that proceeds of the criminal activity of a criminal organization is being concealed in a particular place or is there. If the contemplation relates to offenses that are specific. So when a law creates power specific to the Act or provides for the power of search or seizure, is with the cause to suspect is that an offense under the Act has been committed. If it's general, is that an offense has been, is being, or is about to be committed.
I'm getting understand, AJ, and this is where now our colleague has come in, because what you refer to your first reading is to be, the clause will be justifiable in place in this law. Okay, are dealing with something that could be related directly to the criminal operation of the gang in that area. That there's a member in that particular premises who has moved from the house you're going to search. There's property there, there's evidence there, etc. Reasonable cause. That's pretty straightforward. The suggestion that came from our colleague Goulding is that we should, given the current kind of criminal activity and the evolution of the crime in different areas, you should make that general part of the police force where an officer at the level of an inspector certain somebody, I think would then be able to give permission if they can justify the cause.
But it would have to pass two tests. First of all, it would have to be that there is reasonable grounds for thinking that the evidence that is there may disappear if the search doesn't proceed, and also they must, to answer the point that Senator Knight made, that they must be searching for something specific or of a particular type. It can't just be a general search to say, boy,
When
let's
they say
see
working
what might be
type,
there.
But in the situation you're describing, how do we, once you issue the warrant, you'd have to justify that before the court? Or he instructs his officer to look, he'd have to instruct the officer to look for particular.
Mr. Park has been trying to say something because...
Chair, if this may assist, the SG referred to the warrant provision under the MOCA Act. In paragraph 3 of that provision, it lists out certain conditions upon which the warrant is subject to. One, there must be a statement of the purpose for which the warrant is issued and a description of the offense that is being pursued, a description of the thing or things that are to be seized or being sought. Also, there's a reference to time whereby the warrant is given a life of 30 days in this example. And the fourth condition is a statement as to whether the warrant is to be issued either in the day or at a certain time, day or night. Just wanted to add that. That would, I think, assist with the concerns raised.
That's where the warrant is being prepared.
I'm sorry, sir?
That's where a warrant is being prepared based on the intelligence. But in the kind of situation being envisaged here, is where you have called an urgent situation, police in operation, they need to search an additional house. How do you define that, and what condition do you put on it? Because while you can create a scenario that's easy, see a man throw a gun next to you going over there for it, but
the question is, search for what?
How do we define that? Because
But we're repeating ourselves. What
Evening
Mr. Park has read, my position is that it should govern any amendment, that approach.
Even in the vague circumstances you outlined a while ago, Chair, it is possible to give some context within which the search is to be found. Guns said to be on the premises or persons involved in a particular type of activity. Certainly that would restrict law enforcement in a particular way, because as I understand it, the caution is against having a general search with no parameters.
it's essentially, what we're agreeing is that there should be a consequential amendment to the Police Act, JSCF Act, but in that you should still indicate reasonable cause. A consequence. No.
Keep mentioning reasonable cause.
I don't know. Understand when I say reason, I mean you should indicate the reason. Some indication we give them of the reason. Your specific items.
No. Yes, in other words, you have reasonable cause to go and search for a hat, a phone, pair of glasses, a book, or something. You can't just allow people's premises to be searched at large. You just go dig. Somebody comes to my house and just digging up all over my house, looking for what? They are just looking because they have reasonable cause to believe that you're involved in.
Perhaps a palatable middle position could be searching for items of a kind or kinds, so you don't get too precise in terms of what is still restricted.
We're still dealing with the Anti-Gang Act, and I think the member Fort read on the issue of specific thing. Now, a gang operating who, when you get to the venue, you realize that the gang also controls number 12 as well as number 10. What they will have in number 12 is hard to define because the gangs operate in different areas. It can be money, it can be guns, it can be goods. And goods of what kind, you don't know. They import illicit goods to trade. But you never know. They can go and take a whole warehouse of goods. So when you go, you don't know what they're storing there out of their activity.
So
you'll have to list everything.
So what's the basis of the reasonable cause?
If the gang operation.
So you just say, oh, there's a gang And it
No,
operates.
you know that the gang, you're aware that the gang, this is one of the gang's operational hosts that they operate from. You don't know before you get to the venue when it is indicated to you by a credible witness that now this is the police are willing to talk. You have a search warrant for number 12, but number 10 is also occupied by the gang. Because the man who lives in number 10 is a deacon at the church. And therefore he doesn't come under suspicion. The can say, no, that's the house they store the goods in. That's where they store the gun. That's where they store the money.
So go search for the gun and the money. Search for things specific. People still have rights. People still have rights.
Chair, I was just wondering, my understanding was that the only difference here would be that in terms of the person who is issuing the authorization. So even if it's the authorization is being issued by a police officer, a senior police officer, it would still be framed in the same terms which you would require for a warrant. In other words, the same things would have to be specified and met.
All right, so I think the only clarification I need here after that is, do we put it specifically in the Anti-Gang Act, or do we move to amend the JSCF Act?
The JSCF Act.
I'm sorry, I just asking for a little clarification. You plan to put it where in the Constabulary Force Act? Right now, Part 2A of the Constabulary Force Act has some similar provisions, but those can only be exercised during a cordon or curfew. Is it being proposed that you're going to make this? And if you're going to do it very generally, it cannot be just a wide power given in light of the constitutional remit, in light of the protection from search of the person, unless you have the reasonable derogation will apply. So I think part of the reason it has been stuck in several laws, for instance, you have a similar power in firearms. It applies for a specific reason. It was put in dangerous drugs, again, to apply in a specific circumstance for a specific reason. I'm not sure how we are going to put in this general power unless you're going to say, so you have a general search power where you use warrant. Without a warrant, you would have to then specify either the types of offenses or the types of circumstances in which it would apply. I think we have to have regard to what's in the Constitution right now.
It could be any offense that's listed in the second schedule of POCA, for example.
Well, precisely, then you would have identified certain sort of offenses. So it would not be just a general thing being given in a general section of the Constabulary Force Act. That I would have a little bit of a concern with, unless there are some parameters. So if it's linked to some sort of schedule where we list and identify the types of circumstances. So for instance, we already know where we have it throughout different laws. We know the ones we need to highlight. Nobody has talked about the lotto scam law, for instance. That would be one of them, and we can identify certain ones where we would use this type of power. So if we were ever having to justify this in a court, we could show that it is specific. We can try to meet the test that the court is going to apply.
Certainly endorse that position. I think it's very clear.
It's logical to, I don't know, it's so logical. I don't know, that's
constitutional.
The legal man, now she has raised the constitution. It seemed to me that the appropriate way to do it is to stick it in the specific laws, unless you're going to change the constitution. That's it.
I thought an option was to put it in the Constabulary Force Act, but to specify the circumstances, the specific legislation.
It becomes very difficult when you make it general. Once you get this Constabulary Act, it's going to be very. It becomes.
Provision
she actually said her recommendation is that it be the acts under which that power would apply would be specified under the Constabulary Force Act. So it wouldn't be just a general free for all.
Yeah.
but restricted
you could
to certain
say,
circumstances.
You could insert a provision in the Constabulary Force Act that says a police officer, if it may,
Educate me then. Let me ask a question.
if
What you're saying?
authorized in the appropriate manner, which would be defined in a manner consistent with how it was done for Mocha, may search for evidence that in relation to any offense listed in the schedule to POCA. So it can make reference to the schedule to POCA, which is where this act is going to be scheduled in POCA. A lot of scamming is scheduled in POCA. There are a number of human trafficking is scheduled in POCA, and so on. There's a list of 18, I think, offenses that are, or lists of categories of offenses that are covered in that schedule in POCA.
So you're saying that the amendment in the JCF Act would allude to those listed in that. So the amendment would still go to the JCF Act, but with reference to the specific offenses identified in the various bits of legislation. And that would satisfy the need for the warrant or the officer giving the warrant to indicate, of course, the circumstances why he's doing it. Okay.
One aspect of it would be covered by doing it that way. Another aspect of it would be that requires that the authorization contain the same types of information that are in the MOCA provision.
Yeah.
And the question is, who can give that authorization and in what circumstances? And the idea was you could give, a senior officer could give it if the circumstances are such that if you don't give it, the chances are that evidence is going to disappear. Yeah. So those are the only, otherwise if those circumstances don't exist, then you get a warrant.
No, the other circumstances get a warrant. I can see the need for warranting, and that persists is the exception we're looking at now where it is justified. But I think we seem clear now. Any further, the amendment would go to the JCF Act, but with reference to specific offenses that are listed on the various schedule of the offending the base of the lot, right? Okay. That seems all right. Can we move on now then? If AG, that seems reasonable up to this point. Member Ford? And members here?
Chairman, we will do the necessary checks in the chambers to ensure.
Okay.
We have enough guidance.
Okay.
We know what the Constitution guarantees, and we know what it prohibits. We know the standard of derogation.
Right.
We are striking a balance between an effective investigative tool and the protection of the guaranteed rights. So the real issue is when you can properly provide for the power without a warrant.
Right. That is the cause.
So we understand the issue and we'll know how to craft it.
Coming out of this, I need to have that done, that we can use that power where you have good evidence that you're operating a gang in the district. Because the truth is, if you go into a district with a gang, you may have to search all the houses. Okay. Forfeiture of assets upon conviction, any?
That, by the scheduling of this legislation's offences in the POCA second schedule, it brings into the whole mechanism of forfeiture.
Yeah.
That's how it works.
The amendment we're doing now on the schedule will cover this. Okay. I suspect that's what you're asking to be clarified in it. Okay. AGL, you'll get a copy. I thought I'd come to you. I'll get it to you. So before we come for Tuesday. Expect too that the recommendation from MOCA to cancel license and etc. would cover on the same forfeiture, right? On page 23 now, we are moving from all of 21 is really a warrant. But when you get to seizure and provision and to other legislation, I'm saying coming all the way over to MOCA recommends that it should result in the immediate cancellation of any license or contract that had been awarded or issued to the accused person by a government agency. This should come under the same issue of seizure.
It's a little different because seizure and forfeiture and so on relate to criminal property. Whereas I think what Mocha is saying is that if you're convicted of an offense, a gang offense, and you have contracts from the government to be doing works, that conviction should result in those contracts being cancelled. Isn't that what you're saying?
Yes, that is so, sir. However, the comments of the committee are quite instructive, because I believe what was suggested as a way around is for the Integrity Commission to be involved as a way of, because if there are public works in train, then to cut them immediately would, not be very practical. So there should be some sort of formula.
Not impractical. I think something like this you should just be decisive on it. It's not impractical. No. What you do is, if it's a works contract, the public works have the capacity to take over immediately. Just shift the work, you cancel the contract, public works pay for what is done, and start the work at a different point. And if they need to get a new contract, if they figure they need to get a contractor, they go to the NCC for it.
It's not as easy as that. Whilst
You got more involved, but
well, no, I'm going to show you. Whilst I like the idea, let me tell you the difficulty. It's not every individual who is convicted at first instance remains convicted on appeal. So if you cancel on a conviction at first instance and the person succeeds on appeal, the state automatically has some liability. So I think
I see that.
This has to be thought through as to how the process goes, whether it's automatic cancellation, suspension, or some way of preventing the person from acting, because I understand what is being aimed at, but I'm not sure that we're on target.
There are also other potential
I tend
issues.
to.
It might not be a contract of works. It might be a contract to supply a piece of equipment which is vitally needed by a hospital or something. So I think if you're going to go this route, there would have to be power for the court to make such transitional arrangements or as are required to ensure the best possible outcome. And that's obviously not drafting, but the concept would have to have some flexibility in it, so that you don't create a situation which has all sorts of other adverse consequences that weren't even envisaged.
Well, think clear thought. No, let me look at it in a layman's way again. I'm prepared that the government of Jamaica, they should take the risk of losing a second case. In terms of flexibility at first case, I agree. At first call. In other words, you don't want to deny supply of equipment. It is crucial. And if it's a company, the court gives instruction to have someone that's acquired, whether the institution or some other public body. But in terms of the fact that...
Or the payment. The court could order that the payment be made in a particular way so that it doesn't go through the hands of the convicted person.
I'm comfortable with that, but I think in terms of, if you're going to lose a second... we might have to lose some, but I think the situation is... proportionally, the state is big enough to take the risk until the other things come, rather than delay moving it, because
I'm thinking through.
It's in the Constitution, is it bad law? But I don't think it's bad law either. I think you're trying to correct a mischief that really needs correcting.
No, this thing needs some more thinking.
But there could be mistakes made, and there's a mistake that you're going to pay for.
This thing needs some more thinking through. It needs more thinking through as to how you achieve the objective. I think we are settled on the objective, but the route to it is something that we have to think about.
Chairman, I do share the view that forfeiture of assets on conviction is something that is already part of the law. I understand the rationale for wanting to separate a convict from being in a position to earn more, and especially from the state, and acquire more asset. I understand that. The reality is a whole complex situation, and perhaps where a convict who is going to be subject to forfeiture of assets is a party to a contract with the government, then in the same way that we have a provision for determining interests in assets that could be the subject of a forfeiture order, we could provide for some court procedure to determine how existing contracts can be dealt with, but being clear that ultimately the law is aiming to separate the convict from the capacity to further earn, and especially earn at the expense of the state. So for property, where we currently, the procedure allows for the court to determine if an innocent third party has an interest in the property and so on, I think we can provide for procedure akin to that kind, where determination can be made.
All right. Well, so so it is a structure where how we write the amendment. Well, we need something. From my point of view, we need something, and we need it in this law. A lot of the things you're saying is that the criminals themselves are smart. They understand the law. So, they're not going to have some innocent name stick on his company name. Poor person don't even know the name on it. They just sign a document for them friend one day. All the money goes in there. I mean, this happens every day in the city I come from. People have enriched themselves because man dead and leaving millions of dollars in his name, and his family can't get it. It happens not one time, two times, many times. Now, how do you... and the country needs something here that can separate, and it cannot be... It has to be clean, that we can separate a criminal or convict from his property and his privileges that he acquires by various means, whether government or otherwise. Once he's convicted, if we're going to fail second, the boy have to do it. But I think we have to just find a way to that the moment we lock him up and take him.
It appears that the real issue is whether the termination should be automatic on conviction, and valid issues have been raised about that. There seems to be no disagreement of the desirability of the law providing for that separation, but it is how it is to be done in circumstances where you will have consequences. So the proposal is that it be automatic on conviction. Now, among the issues raised is that a conviction may be set aside, but we do know in law that a judgment of the court remains valid unless and until set aside, or if you have a stay of execution, and we don't normally have stay of execution on verdicts on the criminal side. But I think it should be, we can provide for it as a court process.
So if it's set aside, you
and
pay the man.
issues are determined in that process for the order to be made.
Yeah, I mean, the range of orders that the court could make could range from termination to suspension, to orders relating to the payment of any consideration, to and any other order the court considers just in the circumstances. It can give a very wide jurisdiction over.
We need something here that allows the court, once we get a criminal, to separate them. We cannot. First of all, if we do that now, I think the public will take us as we're not serious about this thing, quite frankly. I think Paul's are heavily involved in this.
And I think there is agreement. Certainly, I'm not hearing any voice of dissent in terms of the objective, but it is the how, not the what of it. And we do have, it's an application before the court for an appropriate order to be made, depending on the circumstances of the case.
I think, quite frankly, we're just going over accepted ground. We're spinning. The objective is shared. the route to that objective is a matter that the legal officers will go through. They want policy. Once they see what the policy is clearly, then they now do the drafting. That's why
That you're allowing the legal
reform.
officers over here
Yes.
and the draftsman to do. Okay, on the advice of maybe in a different capacity. All right.
I'm not clear on the concept here. What is being proposed? Is it that there's something bad about the contract, or is it that you're contemplating this as an additional consequence of the person having been convicted? Because I'm not sure.
It's a consequence of him being convicted. Because
but then the provisions of Proceeds of Crime Act would deal with any property that could be said to have been involved in the commission of the offense, or to be a proceed derived from the commission of the offense.
I did ask
so
that
I'm
question.
not sure what is being targeted.
I did ask that question if the Proceeds of Crime would not cover this, and they said it's a little bit different. So I need to be advised, and then when you leave, just clarify the policy for you. Technically, what you see here now is references made to any license or contract. Now, first of all, if the person had an adverse case where they shouldn't have had the license or contract in the first, but this might be a new case. Once they're convicted, they're saying there should be separation.
Could be a
not
quarrying
only
license, say.
Yeah.
It could, it could be a quarrying license that they have.
It could be a firearm license too.
Yeah, it could be a firearm license, or it could be a contract to do certain works.
Yeah.
And I thought that.
Yeah, that's technical thing, and what they're saying here, what the object here is that you get a gang leader. Let's look at the mischief we're trying to correct. The gang leader comes in. No, I need from my officers here. I need to tell. Okay, the gangster, who is in our language called the Don, is in charge of District A. Every contract goes in, indirectly or directly takes control of it. Okay? And he earns the money from it. If he's established for a long time, in fact, it goes in his name now because he has got the point to say to accept he's the man in charge. What they're saying, once you can find enough evidence to convict him as leader of a gang, beside his property that he's acquired in terms of houses, cars, etc., you find that he now has 2 firearm licenses, a government contract to supply the police station lunch, a contract to do the road that is being fixed in there for $2 million, and other benefits derived from his influence in that community. I'm saying the law must be clear that you separate him from all of those at conviction. How you do it, I don't know. That's the policy that I'm getting at. And that's I'm not going to state the law now. Whether you put it here in anti-gang, or you amend somewhere else, or you attach it to some schedule with Proceeds of Crime, I don't know. But we need to have that clearly done.
I understand you. And I want to know now, how do we treat with a politician who is a corrupt creature, and that corrupt creature recommends a gang leader for a contract or his company? How do we get that rascal to be a part of the prison population? And the rascal about whom I speak is the one who made the recommendation, because we are replete with examples of this happening. So it is not just a matter of dealing with the Don, who may very well be carrying out the work very effectively and efficiently, may very well. But because he's a criminal.
We share your concern.
But I don't see it reflected
no, it's not,
here.
All right, no.
And unless it is reflected here, this is meaningless, because legislators must look also beyond just the citizens out there and look to practices within their group which are inimical to the well-being of the state. And here I don't see that.
The basic policy articulated by the member is welcome. I thought this was covered in the Integrity Commission Act. If it is not covered, we should examine how it's done. The same as I've asked that we achieve the objective I just stated for the gang leader, if it is felt that there are those who could prevent were facilitated.
Facilitating a gang is an offense under the anti-gang legislation. So if you can prove that the rascal, knowing that this was a gang, funneled facilitation on the state benefits in that direction to enrich them and get his own piece or whatever it is, or
I've spoken that facilitation must include all of the professionals involved: the politician, the lawyer, the accountant, the banker, who facilitate the gangster getting his money in the system. A, to get the benefit; B, to rinse his money to the system, and the doctors who
start with getting the contract. That's where you
start. But I say all facilitators must be involved.
I'm not being.
Remember, you are correct, but you also. I'm not here to try to fail, but remember, under the law, no contract is given by a politician.
No contract is what?
No contract is technically given by a politician. They allow you till they follow the procurement process.
No. Politicians recommend people. Don't tell me that. I know that.
Katie, remember.
Chairman,
I'm saying
politicians recommend people for contracts.
Especially if it's direct contracting, if there's no tender process.
Contracting is what that's fair, but above direct contract, they can always say they follow the procurement process. I'm saying, and facilitation will go beyond those recommendations. So facilitation covers whatever they do to get the individual involved. That's why I use the term facilitation. Because the first you maybe do is get him registered as a contractor, you don't recommend anything after that.
So if somebody goes to an accountant to establish a company, and that person happens to be a rogue, and are you saying that the accountant could be charged?
If he's aware? If he's aware that
he is, yes, he has to be, just like the politician can.
No, the politician is in a different class, and I'm telling you, Chairman, I am so. We're not in America, so I can't use the word I want to use. I can't use it. It's not used here. But let me tell you something. Come. I heard or read of the Prime Minister going to a meeting of the Police Federation and saying police must stop hugging up Dons. And the next thing you hear the police saying, and the politician. When I was Minister of National Security, I once made a statement that I'm going to kill me over. I said, politicians are playing footsie with Dons. The problem is that the police, for the most part, seemingly fear the politicians so much that they will lock them up. So we can't just talk about everybody. The guy who sell a hoe to them, that he facilitating them, and the guy who did. Start where it commences. Deal with it in its heart.
think you have to have a start, but in the current context, and from what I understand, I cannot confine it like that. Facilitation of criminal organized Jamaica is big business involving serious professionals, way beyond even politicians. Politicians are into, in fact, there's more petty facilitation among politicians who finally come on the road and give him money, and they shouldn't do it. And we have to have the law to prevent them doing it. But it cannot be confined, because I know there are organizations in this country that are feeling bigger than even government. So, it's exciting to say it that way, and it's popular to remember, but if we are dealing with facilitators, we're dealing with facilitators. From politicians, lawyers, doctors, bankers who take the money and do report.
Teachers.
All of that. No, I don't find too many what the teachers do. They teach your children. I'm talking serious business complication now. Lawyers, doctors, politicians, accountants are the critical elements in facilitating criminal organization. They must all come in the same boat. The politicians have no more credibility than doctors and accountants, quite frankly.
All of them, but politicians are the worst. Make people ashamed to be a politician.
From what I'm hearing, Chairman, the concern that is raised has to do with what is said and accepted widely, that there is a link between criminal organizations, gangs, etc., and politicians. And the question, and also the facilitation of the criminal and the criminal organizations by the politician through the provision of contracts. So the question that would arise from what has been raised is whether this law that is now under review should make any specific provision for that. And if it doesn't, can it be said that the law, there is any genuine effort being made to credibly tackle the problem and the concern that is in the society?
Yeah, I hear, and I said this particular recommendation is to deal with the separation on the conviction. What I'd like to look at is the next clause that deal with facilitators, because the facilitation is, and one member Golding referred to it, is where that would come. And I don't know if that clause refers to it at this point, but I'm happy to look at it, because we need to look at it.
But just
I think one other thing in it is that there are corrupt politics in the system, just as there are corrupt other people, is now established, but not one, quite frankly, Let me say that speakers want to involved in a big inner city concerns like a colleague. As things change, the criminal organizations in this country exceed political operation now. The big criminals who are really getting the big money. Are we above any MP giving them recommendation? That's just a fact of life. Far, far above them. The real big criminal leaders that we need to catch. They don't need some recommendation from some politician to do what they're doing and to make big money off the system.
Chairman, so I think we can agree that it is an issue that needs to be addressed, and the question is, where do we address it? If within the award of the contract, that arena, we have gone way down the course with our procurement rules and the modernization, whether that can be addressed there in addition to anywhere else.
No, the procurement rules currently in the law that we passed, the procurement, and I was involved in the host, does cover gangs and dons who not awarding contracts to them, and serious consequences are there. So it has been addressed in other areas, but I think what the members are asking is to be specific for facilitators. And I think where we should look is in the very clause in this, which seeks to apprehend. I think it's the Anti-Gang Act that seeks to get the facilitator. Am I right, Ms. Grant? I think somewhere in the Anti-Gang Act, facilitators are referred to. And that's the clause that we need to examine to ensure that it covers everybody. And it is and I guess what we'll be looking at is facilitation. What kind of facilitation the facilitator gives?
The offense is at Section 8.1 of knowingly providing a benefit to a criminal organization, or knowingly obtain a benefit from a criminal organization. 8. A person shall not knowingly provide a benefit to a criminal organization. A person shall not knowingly obtain a benefit from a criminal organization. And if you contravene that, then you commit an offense. And in determining whether the person has committed an offense under the section, the court may take into account all factors that appear to it to be relevant, including evidence of activity by the person that is consistent with his having financed in any manner or otherwise provided support to the criminal organization or for any of its criminal activity, and evidence of the possession by that person of article or documents of a kind that would give rise to a reasonable inference that such articles or documents were in his possession or control for a purpose connected with the financing of the provision of other support to the criminal organization or for any of its criminal activity.
But we've kind of gone on to another issue. I thought the issue in the matrix, have we agreed that the technical team will look at, including a provision
I think we have agreed
that would allow the court to make an order in relation to any subsisting contract that the person is a party to with any public sector contract, and with a view to ensuring that justice is done in the circumstances.
I think we have agreed it's for the legal team to find the right language and the right references and the right precedents and make it within that is satisfy the constitutional requirement as well. Is that a reasonable layman's summary?
Chair, if I may, Chairman. All right. Yes, perhaps I should have had a bigger lunch, but I'm a little puzzled as to what it is that we're actually tasked with doing. Part of from what has already been said, some of this may already be dealt with under the public procurement laws that we have. And I am also I'm still a bit mystified as to what it is that MOCA is actually proposing, because I don't really understand what it is, what is a weakness in poker. And this is an additional recommendation that is being made by them. And perhaps I've missed something, but I have not heard anything as to what is the weakness in poker that wouldn't cover this.
You're saying that poker could cover this?
Or public procurement.
Public procurement is seeking to prevent the individual being the benefit of the influence of any of the facilitators or in particular the elected politician. I went along with this because I think this is so where that's failed. In other words, the gentleman has been able to organize himself to bypass the rules in the procurement process.
Chairman.
And when he is eventually apprehended and convicted, then you have to apply this.
Chairman, Bigwig, Mr. Bigwig is eventually charged with gang offenses. He is convicted. His company has a license to do sand mining, right? He has a security, he's registered as a security company, yeah, and has firearms, all of that stuff. I think Mocha's point is that we need to stop using state resources to empower criminals. And where we've managed to secure a conviction, there should be consequences that flow from that so that those benefits from the state cease. And I think that's really what. Now, to the extent that it's property that the person has, it may be subject to forfeiture. But I think they were focusing more on licenses and contracts that exist at the time that the person is convicted. And it can't just be in their name, it must be in any entity that they control, directly or indirectly. And that should be something which the court can make an appropriate order to bring an end to. An appropriate order would be one that takes into account any consequential arrangements that need to be put in place to us to avoid any disruption of any kind. Yeah.
And if I could make one clarification, poker would not be directly applicable in these circumstances because it would have been legitimate income. And Member Golden is very precise. in terms of what is the objective that is mooted in this suggestion.
At which point, Chair, it would seem to, at least to me, that the public procurement rules are what needs to be looked at and how the administrative arrangements in relation to contracts. If Mr. Park is saying that we're talking about legitimately acquired income, then not only would it not fall under poker, but I'm not entirely sure how constitutional it would be to do
no,
what
I
is
don't
being
you can
suggested.
trouble him. Yeah, it would go against the constitutional trouble him at that point. What I'm saying, when he's convicted, when he got his contract, he was, as far as the there may be intelligence, but as far as he has no record, he has an established company working for everybody. His company he's a highly respected individual in the station. But MOCA and other agents in pursuit of their law enforcement activity finds out, is able to get enough evidence to take him to court and convict him. When he's convicted, he still has all of these benefits, and they're saying they should be terminated unless he can.
But, Chairman, why would that not fall squarely within Section 8 that was just read about providing a benefit to a criminal organization? If the person has been convicted and this is an entity that is associated with that person, it would then be a criminal organization, would it not?
Benefit would have been provided already when the license was granted. So the question is, how do you unwind that situation? I think that's what MOCA is trying to.
I'm to advise. All I want is that, I said, the policy is we need to find a way to ensure that those who are leaders of criminal organizations, gangs, who are benefiting from public license and contracts, otherwise, that once they are convicted, because the challenge we have now is that many of them are not in court, and the ones who are benefiting optimally are the ones who not went, who nobody have any question about, publicly anyway. The little guy down the road who may get a direct contract for small money from a council down the road, that must stop too, because you only get corruption dealt with at a zero tolerance level. But he's the least of the offenders.
Chairman, if you may, I know that the technical team has been given some instructions, but instructions to me seem a little limited. We would want the opportunity to look through the public procurement legislation. I'm very concerned because when we're dealing with property, remember that the reason POCA was crafted the way it was crafted was to meet a constitutional test. We can't just always think that you can just take away everything from someone because they have been convicted. The courts have agreed that even convicted persons have rights. So the point is we have to make sure that whatever we are doing, we can justify. If we have legislation that deals with that situation, let's look at that to see if it is we need to beef that up or if we need to link it to this one. But I would like us to just get some. I don't want the committee to give us instructions that we are to just fit it within this, because it may not be the most appropriate way to deal with this.
You need some time to do some research.
Sure, and I agree with that. I'm just saying, I just want it to be understood what it is that is being sought. And it's essentially to somebody who's convicted of a gang offense, that they no longer receive the benefits from the state in the form of licenses and contracts, even for a period of time or something. But that those must. Yeah.
Is that clear enough, colleagues? Mr. Bailey, would that be clear enough? Look, and therefore, the remit is to now examine the existing legislation to see if we are satisfied we need amendment rather than creating a new clause. All right, fair enough. 23. There's assaulting, yeah.
Just, I need help. Someone who is not a member of a gang commits an offense. And has a contract with the government. is it in our contemplation that that person should also suffer some consequences?
I detect that's one of the questions that are being raised, because this we are referring specifically to gangs and criminal organizations. And given what was raised by the SG recently, it looked to be like they'll have to examine the other bits of legislation to see what they cover, and if these are covered. Plus, it would seem to me that the individual who may have been the benefit of some award of contract license in his time, then he commits a crime and is convicted, is in a different category. Right?
A lot of thought.
It would be, and she does use a pretty instructive term for me, that convicted persons still have rights. Mr. Knight? Remember Knight? I said the good lady used the expression I find instructive. She said even convicted persons have rights.
Yes.
So what we're alluding to here is that what my interest here is a different category. Those who are identified as members of criminal organizations we call gangs. Okay.
Can't be just gangs.
They could be ineligible for licenses and contracts for a period of time.
The procurement process refers to people who may have adverse traits and other things, and so too does the facilitator clause in this. So allow them, we have asked them to look at how this fits in, and when we get there.
But in doing so, they need to take into account that these may be subsisting agreements and subsisting licenses that have already been procured prior to any conviction. I think that is the issue.
I'm saying in the case of an individual or business, that is clear. In the case of a gang who may have used his power as a gang to get those things in the first place, that's why I'm saying I'd confine the aspects of this. The gang need to be identified in this process. All right? That's what challenge, even though gangs and their leadership is the challenge of dealing with, though. There will be individuals, cases otherwise, and those have to let, I suspect, the law to deal with them in different ways. On page 23, the DPP comments on the assaulting of a police officer in the lawful execution of the duties, incorporating a provision to criminalize preventing an offense, an officer from lawful execution of his duties, coupled with the appropriate sanction, which will act as an effective deterrent. Is that not yet covered in any existing law, and do we need to incorporate this? Can I ask on member, here as a member, I'm saying, I'm asking the AG, I was a lawyer, not as AG, and I'll ask her SG to comment separately. The assaulting of a police officer in lawful execution of his duties to be criminalized. Currently covered, if not covered, do we need to include it here? I think we need, if it's not covered, we need to include it. Same page 23.
Covered, Chairman, we have currently in Section 30 of the Constabulary Force Act, it's a common law offense and the penalties provided for statutorily, and that was updated by a consequential amendment to the ZOSO law.
And it will apply generally?
Yes.
Right. So why would the DP bring it? DP
assaulting or obstructing the police.
Why?
In the execution of his duty.
Is there anything special about gangs obstructing police? The fines were increased?
Fine was increased to $1 million, which is the general jurisdictional limit of the parish court.
I'm advised by my legal colleagues as to these matters, but it's something that I need to be covered on policy. We need to cover the police officer in his operation, right? And it's a challenge on a number of occasions.
It may be that this is not a very good summary of the point that was made by the DPP in their presentation, because obstructing police and so on, that's dealt with in the Constabulary Force Act. That I think they must be aware of. So it may be worthwhile looking back at what it is they were specifically concerned about.
But if you try to...
What's an DPP? Mrs. Moore, would you be able to comment on that now? You'd have to go and check back on. Hmm? No, DPP, right? Mrs. Moore? Yeah. Is it something you could comment on? You have to research and see what.
Sorry, where information had been gathered by the police and there was a sort of tipping off done in terms of the source of that information being revealed somehow, and in that sense obstructing the investigation. That is what was the wider context as far as I recall it at the time.
And that would not be covered under the current JCF Act?
Not as far as I recall.
But you just use
I think
word.
you're correct, Mr. Moore, you're correct there, that it was that kind of obstruction we alluded to.
Well, both of you know, Counsel, you use the word obstructing, that it would, in those circumstances, amount to obstructing. So then, and there is such an offense.
Just refresh your memory on the point to see if it...
All right, we should maybe get some further advice, but because it's an important point. Now, would that mean then amending the JCF Act again to ensure that...
The issue of tipping, I think Mocha had also made a point about tipping off.
Tipping off
Yeah.
an offense.
Yeah. But I'm not sure if JCF was only concerned about tipping.
It might be exact, but I know that was DP concern as to the gangs getting involved in somehow by their contacts and other facilitators be able to obstruct the pursuit of the investigation. Now, I don't know if we're covered adequately, fine, but if the DPP brings it, I'm a bit concerned. But I don't think she should have brought it without there being some
Mr.
issue.
Chair, if I may, because the AG had been making reference to the provision, I don't know if it was section 30 of the...
Just the penalties that's provided. These are common law offenses that exist.
Yes, and to say, I believe that the Attorney General has shed light, because the context of the submission, now that I'm looking back at it, I know that at the time Mr. Taylor had made reference to what had been described as the meager deterrent given the paltry fine of $2,000. Now I heard the Attorney General saying that has since been updated, so this is
2017.
So this is no longer what exists. So we came to the position that as far as the fine itself was concerned, because I believe it was raised previously as well, it would have been addressed based on the amendment that has been made to the fine. Yes.
Do you remember? Now, when we get on to page 24, we get on to the contentious issue of pre-charge detention. What are we, AD, remind me that we're abolishing that altogether? The next page, 24. We have the vexed issue of pre-charge detention. It was proposed by Mocha that the police be allowed on the act with a period of pre-charge detention of 7 days, possibly extended to 14. This comes into some bruise up against our constitutional rights. The DPP's response was the possible establishment of conditionalities in terms of monitoring to be done. Whereas the JP, I don't know if that's adequate, some of whom had been well trained, the condition would ensure that police are held strict protocols that are transparent and reviewable until the matter was before the court. Precedence would be for a special panel of JPs prepared to conduct daily reviews of those cases instead of parish court judge whose objectivity may be compromised. Well, I'm not sure how that, if that's putting it right, but understand what is intended here. What is the legal advice on this matter now? I know this is the one that I was run into.
And you may recall that this issue is under consideration, and that a paper has been produced by Law Reform on the general revision of the Bail Act. Mr. Bailey, yes. And that the bar has also made its own contribution on the issue. So it's a more general...
It's being looked at in a more general way. But
to include the issue.
Include this issue. But we know there are some headwinds, strong headwinds blowing there.
I think, Chairman, the concern, a number of issues arose. So the practice of detaining persons for an extended period without charging them under the guise of being investigated for offenses, and in some cases, genuine investigations are being done. Police just not at a stage where the person can be charged yet because the victims themselves may be part of the criminal environment. And the issue arose, and how do you deal with those persons who are regarded as suspects, for whom the police would want to do some monitoring in a way that doesn't lock them down, keeping them in custody. So the matter is still being thought through.
Thank you. So this will be dealt with in the broader legal reform process. You know, I mean, personally, I like to live a lot over. Not on a serious note, gang, I don't want to disregard the constitutional rights, but in a lot of these communities where you're seeking evidence, there are a number of factors. If the community feel the police is, the investigating police themselves implicated, nobody wants to talk. If not even the police do not investigate, that's one big problem. But then again, once a person, you're dealing with a gang, once any member of the gang is on the street, no member of the community will talk. Got a fear for their life. And it's a genuine concern. Because if the gang is 10 men and you lock up 9, the one left on the street job is to go take out all the witnesses who are convict them. And that's the reality of the gang wars.
This is an issue that the state has been grappling with for an extended period of time. And I believe it contributed to some of the reforms that have been made at the highest constitutional level and in other provisions. It probably would be helpful because we keep hearing that the police have intelligence on the number of gangs that are operating. Many of the members are known. How many of these persons, I mean, what is the data, the real data that is going to inform the decision-making process? How many persons on which the police have intelligence that they're trying to convert into evidence that requires some form of monitoring, who increase, who are alleged to be part of the increase in the crimes that are being committed? What really is happening on the ground? I'm very troubled by the absence of the data, because we can't hear in one breath that the security forces know who the people are, that they are monitoring. We know that there are genuine difficulties in bringing prosecutions, genuine difficulties in completing investigations in a timely way, but we cannot continue to have it always.
I understand the need for data.
And I'm troubled that we're not getting the data to properly inform the policy decisions that we are to take.
I appreciate your concern, Member Fort, and speak from a purely scientific background. That's the correct way to make policy decisions. But the truth is, deal with gangs, I don't know what data you can get. Having gone through, seen the process at the community level, we say, well, a gang is operating inside to kill witnesses. And I've seen, it may be anecdotal, but I was there when people start killing people along a street just because they are witnesses to a route that is used by a gang. And what the police is going to say, the police can say, look, I feel the gang has 50 members. We don't know who do the shooting, but we know they're killed because of the gang. And nobody in the street will talk. You go to a crime scene and because of who you are, man, say, well, see the man who shoot him there. Though. You even hint that he told you that and he's dead tomorrow morning. That's the atmosphere operating in some communities now.
Chairman,
you're not going to talk.
Even anecdote is informed by something, and it may require taking additional step. I'm just concerned because this is one of the major areas that trouble us as a nation, and we seem to be making decisions almost from the same place, and we're not yielding the kind of results that we should yield. And I don't think that we can continue to
I hear your concern we're going
proceed
about.
as we have been proceeding.
It's where you go. You see, it's where we are now. How we got there, I think, is the real challenge. You know, it's how we get back from here to where you want us to go, where we can actually establish empirical data for everything that we do and we should, because we're at a place where the challenge is. We know, and many of us know from just being on the street. Beside what is happening, what intelligence you may have, we can have, and I'm sure we can get some hard intelligence, but the numbers, when fear takes over a community, the policy is what do we do legitimately to restore the community?
Remember, Chairman, that you can gather data from intelligence, you know, even if it is not converted into evidence that can ground a prosecution.
Community becomes the operational base, the entire community becomes absorbed in it. How do we get from there to begin to isolate it? That's the question. I'm not saying we should do it. I know we should breach the law, but I need a kind of, this is what I'm looking at.
I honestly ask, does that exist right now? Does it? What you're saying there, Chairman, that there is this fear all over the place that people...
In a particular community where you need to get data from, there might be fear as well as acceptance. It's two things got to go together. Those who are not members or supporters or family members fear the particular gang, and the others are part of the operation themselves, even though they're not involved in criminal activity. So the entire community now becomes a part of an ecosystem which supports the crime. How do you put that in empirical basis? And how do you pull it back from there legally to a point where it becomes a normally functioning community in which you can now identify, separate, and count?
Well, one thing you won't help is criminalizing everybody.
No, I'm not criminalizing anybody. I'm just saying the entire ecosystem become overwhelmed by the criminal operation. That there are those who are not engaged are fearful for their life, and that's all the reason.
But you know, if this is why there is need for a holistic approach, because what you're saying, you know, you're asking a question: how can such a community be normalized? And that is a part of a crime plan. That's what it is a part of. That's how that question is answered. So, for example, what are the kind of interventions needed? The Ministry of National Security recently.
Remember, you're aware in the Ministry of National Security, you have sat in that chair with distinction for a number of years. We have spent billions of dollars on seizure intervention. I've been the architect of many of that in my constituency. If you want the one most big person, look, we have the kind of money that's been invested.
No, you notice what I said? I never said you must go spend money. I said we have to look at...
I said social intervention, and they go from... Interventions vary from case management to fiscal environment. You can cover anything you want in intervention. The governments of Jamaica have tried it.
Yeah, but at this time,
and I'm not saying it's
having escalated as you have put it to this point, what is it that is being done? The passage of gang legislation?
I'm not saying, a lot of things are being done, but I'm still saying that you have a problem where you have large gangs in a community that, and bear in mind, some of the crime, let me go back a little. There was a time when it was said, and maybe it's the wrong one to you, but there was a point in time when ganja trading, where they go and say, look, take dollars and don't look, until the thing broadened and people start using ganja traders start shooting each other.
1981.
When you come back to the current time, many people see, well, one person describes scamming as reparation, right? That it is not a, it's not a crime for them. It's the consequences of, or the consequences of scamming leads to criminal and killing, felon. But as far as some many are concerned, they see it as a way of repatriation, as they say, which is justifiably taking money from those who exploit the country. So picking up the kind of data you want from that is extremely difficult.
But not impossible.
In the time you may want to resolve some of the issues, it's almost impossible. I would say pretty much impossible.
That is the problem. It's not just the immediacy that has to be dealt with. That's the problem, Minister.
There are many, anyway.
I think we can resolve this issue of the recommendation by recognizing that the pre-charge issues relating to pre-charge detention are being looked at in the revision of the Bail Act and will be addressed.
I take the
there.
advice of you, not only as member, but as AG.
And then we can go on to the next recommendation.
Just a little question here, AG. How would we put pre-charge in a Bail Act? Oh, you don't. Okay, all right.
I'll take the advice on board because I suspect the legal arms are going to
Looks like you want to detain us here.
We're going to finish. I move on to this one. Yeah, we should try and finish by 4:30 latest.
I know you're developing a love affair with the law, but we have to go through provision.
I guess the challenge I have is dealing with rights are individual based. Gangs are groups of people put together. And defining that groups are challenging. That's two different things.
It said that the biggest gangs is the gangs of Gordon House. The biggest gangs are the gangs of Gordon
Mr.
House.
Knight, I will suggest that we maybe need to have a special detention order for the members of Gordon House. Certain pre-charge detention would be appropriate. Right? I have to indicate to him that now that he's out, I will need his legal services. All right, we'll just drag it out by 4:30. Production inspection orders from the JSC. This should be a provision to allow the police to apply for production inspection orders and accounting monitoring orders in further investigation on the act. Where we know. What is this here calling for? What is that order calling for really? I don't quite understand. There should be a provision that allows the police to apply for production inspection orders and account monitoring orders in furtherance of an investigation on the act. Can you, financial, so that is the FID?
Mr. Chairman, I think it's already provided for in the FID Act.
I thought so.
Yes. Section 17.
You don't number, you have to need number, man. I was reading from this document, you need to number the relevant all this for me. All right, I would think, if I'm advised, I would think that should be called the FID. Repeat offenders. 1-3. The request here is for mandatory minimum sentences for repeat offenders. That means they leave, they go to jail, come back, they rejoin the gang. Now there is, I must accept, I didn't realize there's a higher level of recidivism than I had thought. It's about 49%, I understand, which is very high. So we may need to do something in the centers, but we still have a problem with this. Is there any?
I just believe in
a single sentence for the crime committed.
The discretion of judges.
Yeah.
I just believe in that. I don't like these mandatory sentences. I don't.
Look, I am not a lawyer. I don't necessarily have any strong feeling against mandatory sentences, where I think where you might find the discretion simply exercised in the. But I would, on this particular issue, there's a good public health lesson which says specifically, if you're seeking to cure a contagious disease that has an environmental factor, you don't take them out, correct them, and put them back in the same environment. If you do so, you expect them to come back and to be reinfected. So this is a little bit of a tricky one in terms of.
But
there is some responsibility in the state still, you know. I mean, the fines for being, the penalty for being in a gang and to commit gang offense is very severe already.
Yeah.
So I'm not sure this will make a difference, because the difference now comes to where we are in the last point. The state still has a responsibility in its total approach to public safety and security to deal with a broader scope of issue than just incarceration, conviction and incarceration. Okay. This person leaves community A, spend 5 years in the state's company, but they return to the exact environment, and when they go back and find the same gang operating, I don't think you can, I really can't punish him. If you catch him again, you punish him, but I don't think you can give him extra punishment for going back, because it's the same.
And then you're going to put him back in the same environment that didn't change him.
It's a recycling process. So we have to break that cycle.
Well, I'm happy that you are on board with this, so we'll X that out.
Thank you, sir. I take any support from my distinguished colleague. Restitution. This without accepting any extra penalty for repeat. In this particular thing, there are mandated, and there are other laws that have mandated. Restitution now is where you seek to provide some benefit to the victims, right?
You know, Chairman, I remember that there's on the books.
There is?
On the books, and I think there is such a unit, the Victim Support Unit. This is where we have to begin to develop on that legislation, which was an excellent piece of legislation at the time. But I think that maybe it needs to be revisited, and how we deal with this issue of restitution, because I remember that the statute was calling for a victim support fund, and I think, I don't remember now, it had set out ways in which that fund could be provided with the necessary resources. So, because the idea here is one which I think all well-thinking members of the society would support.
there's broad support for the principle.
Yes.
What I need is how you put it in law. I don't think there's any debate here that restitution is a worthy cause to be properly developed in law, and especially dealing with criminal organizations which are extorting, robbing, and other disrupting family life, murdering. If you catch them,
the officers to look at that.
how do we put it in law in a sort of way? I think I'd be advised.
Yeah, Chair, there was a recent amendment to the Criminal Justice Administration Act to provide for a general restitution provision for victims. Yeah. Criminal Justice Administration.
You know, the AG has suggested that each time we get a new law, we need to go through the whole process of informing all the same. After you draft and send it back to us, we have a responsibility to educate all the stakeholders, meaning the various departments, the police, DPP, which is the easiest one, the lawyers in the ministry, the officers of government, AG department, so that everybody, they're all attached to your department. I keep getting saying that there's a law.
That's a long-standing sore issue. I'm happy you have resurrected it.
I will give you full support from another seat in which I sit, because the fact is you're telling me that, you know, it's a matter of using what we have, and I am a great fan of that kind of activity. I'm not an edifice builder. I like to ensure what we have work, fix them, repair them, use them, right? But you know, there's a great public tendency to write new things. It makes better news clips, right, Senator? And the resume. We wrote this, we wrote that. Information, Mr. Bailey, is that the amendment to the Criminal Justice Act gives enough room for restitution. And if needs to be broadened, it would be a matter of strengthening that particular clause. He said no. The SG said no, it is comfortable. All right? This page is covered. I think we should look at coming back. I need to find some days. Taking a little long. We're going a bit slowly now, but no, wait. I think I'll have to forget my love with the law of AG. I need to go a bit faster. We'd suspend. We have a challenge with dates. Now we're going to suspend sitting. Now it's 4:30. I don't think members want to battle anymore. Let us set a date too. But I think we have done some good work today. We only have 6 pages to go, so we should be able to do it in one session.
Just to say, Chairman, in respect of how you deal with habitual offenders, I know we had kind of glossed over it. We're grappling with some issues, and the issue of mandatory minimum. Just to go back before we wrap up.
Yeah, this is what I was saying, that I am not averse to it because I'm not a lawyer, although I know there's a philosophical concern. But in this case, I was saying that I had a concern that in the case of gangs, I'd love some more thought, because the penalties for gang crimes under this act are pretty severe already, which means for longer. But when the individuals return to this exact same environment, you're really not asking them to do anything different. And we should be looking, in other words, a man gets 10 years, well, he gets 15 years, he serves 10 years. He come back, and maybe it is not the Jamal gang that's there, but what he has is no stepper gang, but it's the same gang. And when he left for prison, the 10-year-old is now in charge of the gang, who was his nephew. And nothing has changed, really.
Chairman.
So should we really give him extra punishment for rejoining the state? That's my concern. It's a little bit...
There are a number of things that we will have to reconcile. You would recall that data coming from another part of the justice system showed us almost just under 50% recidivism rate, and how we deal with that. A number of offenses. And then we have a provision in the Criminal Justice Administration Act that deals with habitual offenders. The issue of mandatory minimum comes up from time to time. The research shows that two different approaches being taken. There is a recognition that as a matter of policy, the executive and legislative branch can determine what sentence is appropriate for certain offenses and under what circumstances. And then there is, on the other hand, the issue of the judicial discretion and who is best positioned to determine what sentence is appropriate. We now have the sentencing guideline. There are some areas of conflict that we will have to sit and resolve. And it's not something that can just be done on the fly, because there are deeper issues. But it is recognized, though grudgingly, that as a matter of policy, a government can say, depending on what it is contending with in the wider environment, that where someone is convicted of an offense, having regard to the prevalence of the offense, the aims of sentencing, what would guide the court. In the Canadian jurisdiction, mandatory minimum is, they've gone through a whole series of research, challenging the court, challenges in the court, and policy thrashing out. And their jurisdiction provides for it, but in circumstances where there are aggravating factors. And so we would have to determine whether habitual conviction, previous conviction, is to be treated as an aggravating circumstance. How do we reconcile it with where we are moving the justice system in from retributive to rehabilitative? So there are a number of things that we have to take into account. And then what, if anything, is so unique about the gang culture and, the effects of gang? So it's not an issue we can just brush off if we're going to tackle it in a meaningful way.
It's just in the specific case, I said our friend has a specific concern about mandatory sentences. I don't share the same philosophy as both, but I say in the instant case we are dealing with, I had some concerns in making it mandatory. There are certainly cases where I think you could look at. Well, let's take the extreme one. A repeat sexual offender rated because a serial sexual offender is the kind of thing that I would have to take I think the justification after the second and third attempt to look at them differently. But I don't want to get into a debate on those issues. But in this specific case where I'm concerned, I felt that in this case, I'd be a little bit hesitant in going forward, given the nature of gangs in communities.
We're having some issues. So the society has raised a lot of concerns about what they view as inconsistent sentencing coming out of the court. What is reported cannot always be taken as a full picture of what happens when a sentence is being handed down. But we know that the sentencing guidelines are in place. I don't know if sufficient time has passed for us to see and make an assessment how that has addressed the concerns of the inconsistencies raised in the past. We would have to get some indication from the office of the DPP. So I'd be a little reluctant to jump on the issue without getting some data.
I'm just saying in a philosophical sense, I'm supporting exactly what you're saying. But I'm dealing with a specific piece of it, and I'm saying in this specific case, that's my thoughts on it.
Yeah. Just AG, alleged inconsistencies. Alleged. And I'll tell you why, right. What comes out in the, exactly. But since the policymaker present here is not for it, we can move on.
Chairman, are we going to pause now, or are we going into?
Pause now. I'm trying to get a date.
Pause now.
The
Okay.
only date I have is, well, we don't want to do it on the 19th. We have officially announced the period of the 19th to 23rd as a period of mourning. I don't think you'd want to. So the 26th we have available. We have been given that by the PAC. I know we're drawing it a bit long, but I want us to conclude this.
Yes, Chairman, that as part of the work, because we do have to generate a report at the end of the day, if in the interregnum we could get somewhat of a reconciliation of the
Right.
positions we have taken up to
Yeah.
this point, and we can
Yeah, I
kind of
think
look
that
and
will be very
review
useful
it
now to
while
what we have agreed
have the
to,
rest
what we have
to deal
agreed
with.
to, and what we have
Right.
guidelines we need additional research
Right.
on. So when we come, we hopefully should be able to finish in one more sitting.
And also as a
the matrix.
guide, in terms of the revision or potential amendment of the actual law, what will go in it, what is being recommended for the wider provision, what exists elsewhere, and if there's any need to bring it in specifically, or, because that is how the discussion has been going.
And at 10, this one definitely in the morning. The 12, we have no space. PAC is insisting. PAC has insisted that they want to meet, and they had been meeting habitually in those days. And the chairman, no, that's not your chairmanship. PAC is insisting, which is a standard. PAAC is insisting that they need a meeting on the 12th. PAC. And we have Thursday. What is this? We have the BOJ Act on the 13th. And most members here are a bit concerned about the Thursdays. We could come on. I don't think the late Prime Minister would object to a meeting on the day, on the day of mourning.
You mean on the 19th?
Let's meet on the 19th. I don't think. Eh? No, that's the day of the sitting. Sorry, that's the day of the sitting. Sorry, that's a special sitting. Yeah. Unless the members object to sitting on Thursday. But Thursday knows. Yeah, but the PSC normally meets then we had set it aside, but the PSC insists that it's a routine for them to meet, and the clerk shouldn't have given it to us.
So the next sitting is the 26th.
Yeah. 10 o'clock.
At 10.
Yep.
You can't yield that date for the completion.
We will look at how we proceed from there.
Chairman, perhaps PAC would be willing to yield the 12th. The chairman is here because this need.
That's what
I
you would
don't
have
think
said?
he knew that was what.
Oh, I had made it clear. But you answered in the affirmative.
I thought you were saying on the 20th.
Is the other one?
I knew he was not.
Is the other one who's a little bit more recalcitrant?
No, they have a meeting. The PAAC.
It's the other chairman, Madam. What? It's the other one, chairman. He's more. He has a wider smile, but he's more recalcitrant in matters of this sort. Member Matt Neal is chairman of PAC. What the clerks, you will make sure we get the summaries and the assessment given, requested by them. Yeah. Mm-hmm. Well, we can bring this to a conclusion faster, boy. The problem with Thursdays is that MPs go to the constituencies, am I right? The Thursdays, most MPs, yeah. 26, and let's say if we can wrap up the matrix, and then when we come after that, if we have to take a special day to now finalize the document, yeah. We should be able to finish. We're looking at what's left. One session. All right, let me thank all the members and, of course, all the supporting team. Thank you for the effort. As I said, yeah. All these lawyers here, I converted him to a lawyer, but